one of the terms that you need to agree upon or need to be resolved to get divorced is the division of assets. And how do we do that? So we need to look at the date that you got married and the date that somebody started a divorce proceeding. And we look at all the assets and debts that were accumulated during that period of time. There are, of course, some exceptions, but just generally speaking, all the assets that are accumulated during the divorce are considered marital property. New York is a marital property state. Anything that was acquired before the marriage is typically called a separate property asset, and that would not be subject to division in divorce. Again, of course, there are exceptions, and that's something that your attorney can help you understand. Generally speaking, marital assets are divided 50-50. We have a term called equitable distribution, which doesn't necessarily mean 50-50, but for practical purposes, that's where we start at in the event that someone is going to ask for an equitable distribution of assets, which again does not necessarily mean 50-50. It would require looking at a number of factors that the court would need to evaluate to determine a good reason. A common reason why an equitable distribution of the assets would not be a 50-50 split might be perhaps someone started a business before the marriage, and now the business is continuing through the marriage. So, of course, the spouse has some interest in the business that was operating throughout the marriage, but there'll be some credit given to the person who started the business before the marriage. That may be a reason not to have a 50-50 split, because they'll give more credit to the person who started the business before the marriage.